wanted to, I'm going to press the got it. Here we go. Welcome, everyone. We're so happy that you can join us. We're so grateful for our panelists and those that have contributed in some way to be on this wonderful roundtable. And so as you recall, it was, we have entitled it, How Do We Coexist with AI in Entertainment, Arts, and Sports? And so this is a great way for us to also introduce you to the USIPA Alliance, which was founded by Scott Frank. And I believe Scott is now on the screen with us. And Scott Frank founded Georgia IP Alliance a number of years ago, and it's grown to the US and grown globally. And Scott, can you tell us a little bit about the IP Alliance?
Yes, happy to, Peggy. First off, I just want to say welcome to this wonderful event, everybody, and just so excited. Appreciate Peggy and Bruce's leadership with this, and appreciate everybody making the time to participate. And also, I want to thank our great speakers, George York, Bruce Siegal, David Lowery, Lana Love, Keith Kupperschmidt, and Bruce Berman. I think you're in for a really special session. As far as the USIPA goes, this is a 20-year story in the making. As Peggy was saying, it started out in Georgia, and it's now sprouting all over the country. In the U.S., in many states, we have about 20 states that have IP alliances now, and the umbrella organization is the United States Intellectual Property Alliance. And we represent everybody, creators, protectors, enablers, all the way down to citizens, people who just are recipients of intellectual property, all the great innovation that's protected. If you're not involved, I encourage you to go to our website, usipalliance.org, and just know that we focus on IP awareness and education. We focus on a collaborative IP ecosystem. We focus on diversity and inclusion, and we want to help you. This session is a prime example. Entertainment, arts, and sports. You know, sometimes people don't think about it, the intellectual property related to it. Well, it's really, really important in this area. And, you know, just an example of the different things that we do to get the word out, to help, and to really, talk about some really challenging topics. So, again, thanks everybody for joining. And Peggy, back to you.
Thank you so much. And, you know, just to also say that Scott really knows a lot about IP. He has been leading AT&T's IP work for decades. He's one of the presidents over at AT&T Intellectual Property. So he empowered us to start an Entertainment, Arts, and Sports Committee within USIPA. And so the committee came together, and we formed this vision of empowering intellectual property to advance entertainment, arts, and sports within the USA. And you can see here that the reach and the impact is really to y'all, to creators, educators, protectors, enablers, and users. And we collaborate with other organizations and universities and professional and hobbyists. So this is our website again, usipalliance.org, and there is a tab there that's for entertainment, arts, and sports under programs, so you can find us. The committee, we would not be here without our committee. I really want to give a big thanks to Bruce Siegal, who you will see him on the panel. He is our sports extraordinaire attorney, and but he co-chairs this wonderful committee with me. And just kind of want to give a shout out to our committee members that are listed here: Jack Bernard, Vincent Castellucci, Roy Kaufman, Keith Kupferschmidt, and Miriam Lord, Lana Love, who's on our panel, David Lowery on our panel as well, Julio Mejia, Lita, Rosario Richardson, and then Moa Sharman, David Sohn, Alicia Thompson, George York, and Wayne Overstreet. You can find us, again, like I mentioned, on the USIP Alliance website, and under EAS, Entertainment, Arts, and Sports. You can see it right here, and you can be added to the EAS community. We will be also adding a video recording of this session onto our website as well. And we are very grateful that you're here with us. So we will get started with George York. He is a Senior Vice President of the Recording Industry Association of America. This topic was George's idea. He serves on our committee and on our board for USIPA, and so we're really glad that George is here to kind of kick us off, and then we'll come back to me.
Peggy, thank you so much for your introductions and also for your leadership on the Entertainment, Arts, and Sports Committee of USIPA. Likewise, thank you so much to Scott for his leadership of this great organization and its growth and its really important principles. The AI doesn't like this conversation, so I'm going to try to get the lights back on. Anyway, so we are going forward today with a little conversation about AI, and I wanted to start by level setting. But before I begin today's discussion, I wanted to give some thanks to some folks. First of all, of course, to our panelists for participating in today's panel. It's such a great group, as well as to all the members of the Entertainment, Arts, and Sports Committee. I do think today is going to be a great panel, so let's begin. What we want to do today is frame the conversation and the great discussion that will follow around the topic of AI. And we're going to take a particular focus on this sort of vast and deep subject area by looking at the creative community, the entertainment community, the arts community, and of course the sports community, and the impact and the sort of the potential for coexistence that may emerge from this AI era that we're about to begin with. So what is AI? I think we all have a pretty good sense of what AI is, but it's always important before we get too far into our journey to make sure we're looking at the same map. AI, when you boil it down, is really about computer systems that are trained on likely vast amounts of information, sometimes very broadly, sometimes around narrower and more unique data sets. And ultimately, AI are computer systems which are trained to complete certain tasks. And when we talk about AI, we can broadly talk about a few categories of AI. So first, you have discriminative AI. In other words, when we talk about discriminative AI, we're talking about identifying categories within large sets of data, trying to discern between different categories and organizing data into different categories. Then you may have also heard of predictive AI. This is AI whose ability, and by the way, to the question that's being asked, there are no slides at the moment. In terms of predictive AI, that is trying to identify future scenarios, trying to provide insights into future events, and trying to ultimately generate forecasts about the future. And finally, of course, there's generative AI. Generative AI involves first developing models based on all the data that's been trained for that AI system, and then to go forward to possibly to develop data around those models. In other words, potentially to create or generate information. So within those categories, we're going to spend most of our time on generative AI today, and then we're going to look at maybe some applications for that AI. So first, I think many of you have heard of ChatGPT and possibly of Google Bard. This is using natural language processing. That means the ability to speak in a way that humans speak, and for computers to process that language, use the data and sort and then respond to questions and queries and other user requests. Then you have DALL-E, which does the same thing. It's natural language processing, but instead of creating sort of written text and responses in natural human English, it will create images. And then, of course, we have voice cloning, and there's all sorts of other applications well beyond the creative space. But voice cloning is one that's very important, obviously, here in the music industry for the creators and the record labels that we work with so closely. Voice cloning involves first training models of AI on voices, and then effectively processing that data, augmenting that data, and finally to synthesize voices. So you can go and use the voice of another or to create a unique new voice. These, of course, AI programs raise a variety of ethical, legal, and commercial considerations that we want to delve into deeply today. And we want to make sure everyone who joins us on today's panel understands both some of the potential opportunities that AI brings to the creative space, but also some of the truly intrinsic and fundamental displacements that AI can bring to the creative community. So when we talk about the creative community, we want to make sure that we're supporting human artistry and the arts, the entertainment, and sports that is human-centric. And we want to make sure that when we talk about AI, to ensure that it is not unethically developed or implemented in a way that displaces jobs, that displaces livelihoods, rent, and all sorts of other benefits that human beings who are creators, who are artists, who are athletes, and other competitors in sports derive from the creative endeavors that AI very much presents possible implications for. And so what do we talk about? How does AI and creativity coexist? So there's really two main categories that I want to kind of quickly walk through. The first is inputs. What is going in to train that AI system, to build that AI model? And that can be creative content. That can be content that is protected by a copyright. Protected, in other words, a copyright basically means, hey, I've created content, and now in order for you to use it, I need your authorization, a license, which in other words is a type of permission, and possibly compensation, depending on the nature of that relationship. And that's the inputs. These things are trained. AI models are trained on data, trained on information. That can include songs, that can include musical works, that can include movies. That can include all sorts of different issues that content that creators create, that they have created as humans. And so ultimately, these AI programs are being developed based on those. And then, of course, there's the outputs. This is generative AI. And when those outputs come out, we will certainly spend a lot of time talking about this. They will create products that will be potentially directly competitive to users when they are just selecting the type of content they want to interact with, they want to engage, music fans want to listen to. And so this is something in the output, we want to make sure that, first of all, there's permission. Second of all, that there's compensation. And third, that this is not violating the rights that creators have when they first create their creation at the outset. And finally, I just want to note a development that's happened in sort of this new era, this AI era, and that's the development of a broad and diverse coalition of folks, of artists, of creators, associations, companies, and others, called the Human Artistry Campaign, which is composed of over 150 members in 30 different countries around the world. And this group supports broadly the idea of human creation, human-centric creativity, and the idea that humans should be promoted and not displaced when it comes to AI and various applications and outputs, including with respect to generative AI. And so what are some of those principles that this group of concerned humans, if you'll put it that way, have agreed to? So first, the idea that technology is a tool that is often used by historically, and it's no different than today with AI. So technology is a tool to be used by human creators, but it is not to displace or replace human creativity. Likewise, that human creative works will continue to be important. Human created works are essential to our culture, whether we are in America or countries around the world. It's essential to our history, and it's essential to our future. Likewise, whenever AI programs or AI developers or downstream producers are using works created by creators, human creators, they should make sure that they're consistent with law, right? They're not violating copyright. They're not taking a voice or an image or a likeness away from an individual. In other words, stealing their likeness should not be supported. And also, we want to make sure that it is properly licensed. In other words, that there's a relationship between the creator and the AI developer that is one that is consensual and one that involves remuneration where that is part of the deal. We also want to make sure that big exceptions to the law aren't created to promote AI at the expense of human creators. We don't want to effectively transfer value from human creators who rely on this money to pay their rent and for their benefits, and to help put their kids through school in order for big American corporate technology companies to benefit. Likewise, copyright should protect only, in other words, we should only have legal protections for creations by humans and not for those purely created by AI. Anyway, Peggy, I just wanted to do a quick introduction and pass it maybe back over to you. Happy to be online and answer any questions if that's appropriate. But thank you all so much again, and hopefully this has been helpful in some ways in terms of level setting and starting the conversation, which I know is going to be great. So Peggy, back over to you.
Thank you so much, George. That was such a great introduction. As you can see, AI is very complicated and very simple at the same time. So we're going to kind of get right to it and introduce our panel. So the panel is going to be moderated by Bruce Berman, who is CEO of Brody Berman. And he can also tell us a little bit about his podcast that he has that talks about IP. He is very knowledgeable, and we're so grateful that he has agreed to moderate for us. He also serves on the USIPA board of directors. And also we have Bruce Siegal with Greenspoon Marder, and he is an attorney focused in the sports genre, and we are so grateful that he's with us as well. He also co-chairs the Entertainment Arts and Sports Committee with me and is a board member of USIPA. We have David Lowery. You may have heard of him already. He is the celebrity and founder of Camper Van Beethoven and the band Cracker. And he also is very well educated, and he is a UGA professor. UGA is University of Georgia. Go Bulldogs. So thank you very much, David. David also serves on our committee for Entertainment Arts and Sports and on the board of USIPA. Lana Love, you may have heard of her. She was the voice extraordinaire on The Voice, and she was on Team Legend. If you haven't seen that last episode of the season finale, you will be blown away by her talent. She is more than an artist. She is also an educator and a producer, and she's just an amazing person, just like all the others on this panel. And she also serves on our Entertainment Arts and Sports Committee and the board of USIPA. Keith Cooper Schmidt, I'm going to get the name right here. He is the CEO of Copyright Alliance. He is very well versed in copyright law and copyright initiatives in our country and throughout the world. And so with this, I turn it over to Bruce to moderate the panel. Thank you, Bruce. I'm going to unshare my screen. Okay, Bruce, and I think Pete, you can probably hone in on the speakers here.
Thank you, Peggy, for the very kind introduction. You know, it's interesting. Today we're talking about coexisting with AI, not living with it or benefiting from it quite yet. I think we're still at the coexisting stage. You know, is it a danger or is it a benefit? And I think the jury is still out on that, although we want to believe that it will be certainly a benefit. ChatGPT was introduced as a demo AI platform in 2022. I think it was November 30th. That's 11 months ago, not even 11 months ago. And now it has generated 100 million users and 1.6 billion visits. And that's just ChatGPT. There are others involved, Bard and others as well. So it's really, really taken off like wildfire. I don't think it's grown fast. I don't think any other app has grown faster than it. But despite that, there are a lot of questions and a lot of discomfort with generative AI. And today we're gonna go into that with this really extraordinary panel. Let's start by taking a moment to introduce yourself and how you came to your current career. Lana, let's start with you.
Sure. Thank you again for the beautiful introduction. I'm so excited to be here. My name is Lana, and I'm a singer-songwriter, artist advocate. I also serve on the board of the USIPA and Copyright Alliance. and I am an educator as well. I basically do anything under the sun creatively that they will pay me for. So I have worn just about every hat in this industry because I've had to make a living. And how I came to be a singer, I basically popped out of the womb playing Phantom of the Opera. Here I am. Thanks for having me.
Great. Keith Cooperschmidt, how did you come to this world? I think you started out as a patent attorney, if I'm not mistaken. In another life. In another life.
Yeah, in another life. Don't let anyone else know that. No, I
Right.
actually did. I have a technological background, and so I started off in patent law, and eventually kind of branched out to all intellectual property, and then branched back in, if that's a word, just to copyright, where I now head up the Copyright Alliance, and we represent the copyright interests of over 2 million individual creators. You know, the performers and the photographers and the songwriters and software coders and authors and artists and so on and so forth, as well as about 15,000 different organizations that rely on copyright law. Just the diversity of all the different groups you might think of when it comes to copyright and relying on copyright, whether it's movies or music or books or video games or photography, but even some groups you might not think about, like National Association of Realtors, that has this MLS database that's protected by copyright. And the interesting thing, the issue we're going to talk about today, artificial intelligence, I mean, every single one of them is on the edge of their seat trying to track this and monitor it and have concerns about it. And, you know, with any new technology, there are opportunity and challenges. And I think we'll talk about both here today.
Etha, did you say how many members are in the Alliance?
Yeah, so like I said, we have about a little over 2 million
2 million
creators. Those are individual creators across the country, and actually across the globe, I should say now, because we recently expanded to international. But and then about over 15,000, right around 15,000 organizations that we represent, whether it's a business or a trade association, something like that.
David Lowery. Now, David, I know a little bit about David because I've known him since 2017 or before, but he's a math quant, a professor, a PhD, a 35-year rock lead singer in 2 different bands, excellent bands, by the way, and maybe has about 20 albums out. Now I'll let him say who he is. Okay, David.
Yeah, I started as a mathematician in college, and just out of college did some computer programming. I started a band. We got popular, but nobody wanted to put out records because we were too weird. So I started a record label and a publishing company, and eventually started another band that went platinum, produced records, ran studios, had record labels. I mean, done all kinds of stuff, but you know, basically I've made my living creating copyrights and to a lesser extent trademarks and exploiting those things the best I can. And you know, I've had basically like a 38-year career doing this. I also teach at University of Georgia. I enjoy teaching people about music, business, and stuff like that. So I do that as well. Have a little bit of overlap with sports just because I get a lot of football players in my classes for some reason. We'll talk about that later. We had a special teams guy in our program one time, and ever since then, the other football players have followed him into our program.
Great. Thank you, David. Bruce Siegal, how did you get to your career?
Thanks, Bruce. And my story and my journey began professionally in my career. After law school, I joined what would be termed today a startup. And the startup had the idea of working with colleges and universities and related properties that had trademarks but didn't really protect and license them. And so our organization, based upon models created by the professional leagues like NFL, Major League Baseball, NBA, developed the Collegiate Licensing Company, which has come to represent many colleges and universities and protects and licenses the use of their trademarks. So that is, I kind of grew up in growing and expanding the collegiate licensing company. We also later came to represent PGA Tour, Churchill Downs, and NASCAR and other sports and entertainment related properties. Today, I am counsel in the entertainment and sports practice group of Greenspoon Marder. And so I took the route from being in-house and part of a company to being in private practice. And in addition to that, I teach a sports law and public policy class at Georgia Tech. And David, I too, my class has seemed to attract a number of both pre-law students, but also a number of student athletes. And it's been a great overall experience to be able to combine working in the practice that helps licensees and other brands and student athletes protect and monetize their rights, and also have the opportunity to be back in the classroom.
Great. Thank you, Bruce. Let's start with a question for each panel member. Some questions I'll just ask of certain panel members, but what are the strengths and weaknesses of generative AI search platforms like ChatGPT and Bard? David, let's start with you. What's the strength? What's the weakness? What do you see?
Well, I'm not hugely experienced with them, but I have done a number of things. One thing I'll point out is something. Let's start with one of the weaknesses. The generative AI has a tendency to, what they say, drift or hallucinate, whereby it will just make stuff up. So, for instance, there's a famous case where an attorney prepared a brief for a court and using ChatGPT, and it just made up case law. I have had a similar experience where I asked one of the AIs to write a bio for one of our albums, and it was a beautiful bio, but it cited and quoted reviews that didn't exist from places like the New York Times or Rolling Stones and stuff like that. And then finally, I've also been interested in how it might affect my teaching. So usually at the end of the semester, I'll give these AIs my finals to see what they do. And each semester it's been getting worse. Now it's not like there's not a lot of data there, but there's weakness in that you're relying on it for facts and law and things like that. It's questionable, right? The other thing is it's backwards looking. So, for instance, if you tell it to create a song in a certain style or something like that, it's going to base what it creates on things that have come before. But in the music industry, you often have big breaks, big jumps, big discontinuities, right, in development of music, where I think AI can't predict that kind of stuff. So I don't feel totally threatened as a musician. But if I was a graphic artist, I would be very, very worried right now, because it looks really good at imitating art. Like I put in a guy who does artwork for us sometimes. Why am I blanking on his name? Well, a guy who does artwork for us sometimes for my band, Michael Wirtz. I asked one of the AIs to create something in his style, and it was quite stunning and impressive. So,
Keith, I think you're muted, Keith. What's your take on the good and the bad and maybe the ugly?
The good and the bad and the ugly. So, yeah, I mean, just to talk a little bit about what David was ending about, is that how these visual artists, especially, are sort of under attack here, right? And a lot of visual artists are starting to fight back. There's this great technology out of the University of Chicago called Glaze, Glaze, where basically what you can do is you can change the image of something. It won't look any different to the human eye, but to an AI system, something that's kind of scraping and ingesting a work, it'll look very different. So for instance, you can see a picture of a cat, we'll see a picture of a cat, the AI will see a picture of a giraffe or something like that, right? And that's really, really dangerous, right? I mean, because you're basically tricking the AI, and maybe that's why David talks about getting the results worse and worse and worse over years. Maybe things like that are happening. And I think the moral of the story is that you need to really respect creators' rights. And if you don't, you're not going to be happy. You can try to run over them, but they're going to fight back, and they're going to fight back in ways that maybe you don't like so much. And we see that happening, for instance, with Glaze. Like I said, there are opportunities and challenges here. The opportunities is certainly we have a lot of members who are using and experimenting with AI as a tool to help them with their creative process. But there are also a lot of challenges about trying to make sure that their rights are respected, that AI companies are using AI in a respectful way, in an ethical way. We're not there yet. We're hopefully going to get there someday, but we have a long way to go, I think, and we'll be talking about how to get there, I think, in further, Q&A.
Thank you, Keith. Lana, I think you're muted. Lana, I believe you've used generative AI to create. What's your take on the good and the bad?
I have, and I use it daily for my emails. So I'm always going to be pro artist. David, I love what you said. You used it to create a bio. You used it to test things out to see what it's doing. I don't think musically it is comparable to what it's doing on Midjourney and apps like that are just absolutely incredible at mirror imaging things and taking input and outputting something that is marketable. Musically, we're just not there yet. Obviously, with Drake AI and all of these different voices that we can clone, as George said earlier in the pre-speech, that's the scary part of it. I've spent my entire life building my name, building what you see today, what you hear. There is a nuance that is lost that can only be given by the person who is delivering the message, be it through a paintbrush or through a vocal. So yes, I use AI, but as a tool and not a creator. So I think the most amazing thing is that I don't have writer's block anymore, but I use it to pull one word and I'm not monetizing or ripping off someone else's work. So I think there's a distinct difference in my usage of it.
Bruce, what do you see as the good with these generative AI systems?
Well, I think that, the good is just, having the tremendous wealth of information that's accessible. And, in the sports area, one of the key benefits is that, hey, look, leagues are intellectual property holders, clubs, teams, even individual athletes, including student athletes. They're IP creators and looking for new revenue streams. And with AI, there's the opportunity to really develop the kinds of fan experiences that can take fan experience and opportunities to tie in and associate with your favorite team, league, players to a completely new level. One example of that is with creating highlight films. I mean, it used to be the case that let's say that you wanted to see every touchdown that Tua Tagovailoa, every touchdown pass that he threw during a particular season, and that would involve sort of a manual process where you're going through and you're finding this information manually and putting it together. Well, now with AI systems, you can develop a package of information, virtually instantaneously in a way that you've created a bespoke highlight package just almost instantaneously. On the other side of the ledger, you've got issues with how can this potentially be problematic? And one issue that ties the classroom and NIL opportunities together with that there is a story about a particular athlete that did an NIL, name, image, and likeness sponsorship with a company, Cactus IP, that basically was touted as a program that could generate papers and generate those in a way that could potentially be plagiarism. And so all of a sudden, you've got an NIL opportunity promoting this particular company, and then the issue is, is this, a misuse of your opportunity to influence other people as a marquee student athlete by potentially putting out something that could be used to create unauthorized or plagiarized papers.
For the lawyers, it's questionable whether what the AI bots are scraping, with the data they're gathering, the content, if that's protected under fair use. They say it is, but they do take licenses with some organizations. But who owns the AI response? The person making the query, the platform, or no one? Bruce, let's start with you.
Who owns the underlying IP? Well, I
make a query. It produces a unique response. I wouldn't call it an answer. It's never an answer with AI. It's a response.
The output, I think you mean.
The output.
Who owns the output?
Thank you. Yes. Who owns the output?
Well, I think that the content creator, there's a strong need to get control over and to protect the valuable rights that end up being part of the final product. And I think that in many instances, companies like ChatGPT have largely ingested creators' work without consent, credit, or compensation. However, there's now precedent for a shift in that. There's an instance where OpenAI recently has announced a deal with Associated Press that will allow ChatGPT to have access to historical archives and pay for them. So that this is the first time that at least I have been aware of that a generative AI company has publicly acknowledged that it would pay for content. And so this could be a real trend going forward in terms of creating a model that would allow content to be.
But let's say that the platform is paying or licensing that content, and then the content is used to create a response or have output from the AI. Who owns that?
Bruce, can I chime in?
Yeah, sure.
I guess Bruce's.
Yeah.
So I don't know that anyone owns it. That may be a strange answer, right? I mean, so at least in the copyright sense, right? So the Copyright Office, I think the whole world is struggling with, when you use AI as a tool, where do you draw the line? Like, when do you have enough, you're doing enough, you have enough creativity to warrant the output to be protected by copyright, right? And so let's walk through this. You have a spectrum of copyrightability. On one end, you have no human creativity at all, totally AI generated. That, I think everyone agrees, should not be protected by copyright, and therefore there's no copyright to own there. On the other end of the spectrum, you have something wholly created by a human being. That's what we've had for most of our lives, right? Up until now. And I think everyone agrees that is protected by copyright, or at least potentially protected by that. The struggle is in between that spectrum, right? Where do we draw the line between AI-aided work? So on the one hand, you might have a work that's generated by AI, but has some human assistance, right? So let's take an example here of someone who might generate a short story or a poem or something like that using AI, right? But then go in and change the name and phrases, maybe tweak a few other things. Is that protectable? Then you have the other side of the equation, which is something work created by a human being with AI assistance. So let's say you write that short story, but then you put it into AI and say, gee, my grammar's not so good. Can you fix this up or fix the capitalization, right? I think everyone would agree that should be protected. But you see where I'm getting at here is those are just 2 points on the broad spectrum of copyrightability. And right now, there really is no bright line rule. It can be kind of confusing and difficult for people to understand. And the last thing I'll mention here is the Copyright Office, I think it was back either March or May earlier this year, issued this guidance on registration of works and what you need to do if you are registering your copyrighted work and you've used AI as a tool, what your considerations should be. And it's still a work in progress. The Copyright Office knows that. We all know that. We're all trying to figure this out together. But it certainly is a first step forward. And I think they've done a real good job trying to kind of take on these very, very difficult issues.
Do we need tools? This is for anyone, for everyone. Do we need tools to monitor AI output for accuracy, let alone ownership? David, let's start with you.
Sorry, I had to find the unmute button there. So what's the question again? Just say that again.
The question is, do we need to, are we good enough as people? We need actual assistance, digital assistance to understand what is being, what the creators own and need the tools to monitor the accuracy of the output. Is the output accurate? So in your case, you've seen some inaccurate output. Can we do it ourselves, or do we need assistance to do that? We need bots to monitor the bots.
Well, I think there's always room for regulation with something like this, especially something that relies on scraping everybody's data in a way that becomes like a public entity or something, right? We all have an interest in it. And I mean, I don't think that's a bad idea that there should be some sort of warning. It's like, this is generated by AI. It may not be accurate or something like that. That just seems a no-brainer that should be there. It wouldn't be the first thing on my list for regulating AI, though. I mean, I do think that's important for the consumer to understand. It may generate inaccurate answers to your questions and stuff like that. I mean, we talk about, keeping disinformation or misinformation off of social media and stuff like that. The AI, text output sometimes are completely false. So we probably should have some sort of regulation for that. I would think.
Go ahead.
Yeah. No, I was going to say that I don't want to get ahead of ourselves here, but I think where we really either have to have some regulation or some oversight or just some pushback is what they're scraping. That's to me where you need to really
Lana,
regulate it.
I'm sorry, Lana, your thought?
Yeah, I totally agree. That's really the first line right now. I think artists need 3 things to feel safe, and that is consent, compensation, and credit. And right now, my copyright doesn't stand. I paid so much money and went through so much to own my work, and it doesn't matter. I don't even own my voice anymore. So I think for the first line, the first thing that needs to happen, you ask the question, do we need bots to moderate the bots? Yeah.
I think so.
That's not what's happening right now. We need some kind of computer that is either smarter than the AI or whatever you want to say to regulate it. And what I mean by that is right now, art lives in the gray area, but the rules can't. The art has to be the gray area. But if the rules are gray, then we have no leg to stand on. But if the AI is scraping from a place of consent, a place of permission, paying out the artists, then I think we're all okay with it. Artists have been trying to get paid and fighting for payment since the dawn of time. This is nothing new. So
Yeah,
I think we're just being forced to really define and redefine the rules in which we all, stand on and the playground we play on.
Yeah, I just want to second what Lana said. I mean, that's what she said is so, so important, right? And I think she's certainly speaking for herself, and she probably won't say this, but she's really speaking for all the other creators out there in the world, right? There's a big problem with, these big AI companies, breaking down the doors and looking at these, small independent creators and other types of creators and thinking, well, we'll just take this. There's nothing you can do. We'll just take this from you. There's this lack of respect, right? The creators have an Aretha Franklin problem, right? No RESPCT, right? They lack the respect, that's needed here. And the law, these AI companies are interpreting the law differently in a way that obviously is favorable to them, so they don't have to give these creators their due and what they're due under the law, quite frankly.
Yeah, and in addition to that, Keith, yeah, of course, that's the worst thing, that they content becomes fungible. It's just out there. It could be anyone's content. It's all like fodder for the AI. But even if they were to license the database or the data in which it's based, it may not be accurate in how they present it. They may not present it accurately, even though they have a license to it. How do we know if it's accurate or not? Very often it isn't. It's so convincingly conveyed by a lot of these, by the AIs, ChatGPT in particular, that it seems correct.
Yeah.
But it often is not. Bruce Siegal?
That again, that gets to, to one of the inherent problems of, not only information coming out that is inaccurate, but if you try to probe and go back and force the issue with ChatGPT, it will push back and defend itself. And so, you've got, you're trying to argue with a system that's going to stick with its, stick with the misinformation that it put out in the first place. I guess that's
You're arguing
how
with
it's
a
been
machine.
trained.
With a machine.
Yeah, you're arguing with the machine. And again, I guess so much of this is to be determined in terms of, this issue of scraping. The main scraping case right now is this Sarah Silverman case. And Sarah Silverman, the comedian, actress, author, along with others, is claiming that her copyrights have been violated with respect to her books, which were scraped and utilized in, part of the output product, but, with no compensation for her. And, I guess unlike this case with AP and there being an agreement and compensating for, for footage, this is a battle that looks like it's going to continue its way and be determined by the courts based upon defenses of fair use, whether the use is transformative and all the other defenses that you would throw out in a typical copyright infringement case.
Mm-hmm. Did Google some years back, not that many years back, try to codify or make available all books, I think, and then they were stopped? Keith, you probably remember this.
Yeah, no, absolutely.
Yeah.
Absolutely. There's a case, the Authors Guild sued Google for copyright infringement for what was called their Google Books project.
Right.
And Google ended up prevailing in the case. And that is the case that most AI companies will point out, and they'll say, hey, this is fair use. And they'll say, we'll look at the Google Books case. And my response to that is a few different things. One, fair use is very fact intensive. It's decided on a case by case basis. Okay. And so, so one case is going to be very different than another case. And so you can't just say anything is categorically fair use. I mean, you also can't say anything is categorically not fair use too. it really depends on the facts of each different case. But in the Google Books case, if you're familiar with especially what Google was doing here, very, very different facts. They were using the books for a very, very different purpose. They were using books for the information in the books. So people could search for information. They would know that, oh, you can find this information in this book, right? You want to know Teddy Roosevelt's birthday or how many kids he had or something like that. Well, you search that up, and then the Google book search would show you that, right? But AI is using the expressive content in the works, right? That's very different than using the information. Google had many different safeguards to prevent the likelihood of infringement, right? A lot of these AI companies are not using any safeguards. They allow you to search for style. They allow you to input, a character or something into the prompt, like, search for SpongeBob, and you get a SpongeBob picture out, right? Maybe most importantly, there was no licensing market for Google Books, right? I mean, there wasn't any license. Google didn't have anywhere to go to get a license here. That's very different than what is going on now. Bruce Siegal had mentioned AP, right? The Associated Press recently has a license agreement with AI. Getty does. UMG, Shutterstock. What's that?
I think Adobe does.
So yeah, there's tons of them out there now. There's definitely a licensing market, and some AI companies are doing the right thing. Others not so much. They're not licensing. And the last thing I'll say here is that Google Books, part of the book, they got authorized books. They got real books, right? Legal books, and they copied them and use them. AI is often scraping, not just without regard to anything. They're scraping pirated websites. And any AI company that is scraping a pirated website and using that, ingesting that material to train their AI, number one, to David's point, maybe that's why you're getting wrong information out all of a sudden. And number two, if you think you're going to be able to make a fair use claim and you have unclean hands, it's not going to happen. So anyway, but the Google Books case is very, very different than the situation we have here today. Very long answer to a short question. Sorry about that.
It seems like transparency is really key here. I think if the generative AI platforms were clear about what they're doing, what they're not doing, and they're not very forthcoming, from what I understand, about where they're getting their data from. Do you think transparency would help mitigate some of the questions and problems surrounding this? Bruce Siegal, you're a lawyer.
Yes, absolutely. Transparency would be.
What do we need? What do we need to see more of from the generative AI platforms?
I guess from my perspective, where I'm coming from, I envision there being sources of information that you can obtain through, through the AI source. And it is clear to the person that is looking at that or utilizing that, seeing that, where that has come from. And, hopefully, the vision would be that there is an expectation on the part of consumers that rights have been cleared, right? That, it's not only transparent where this source information
it's coming from,
is protected,
but it's coming in legally.
But it's authenticated in a way that it becomes very clear that and transparent that yes, this is this is the official version of the subject matter, and it's identified as such.
David, what would you need to be more comfortable with the level of transparency?
Well, I'd love to be able to search any AI and go, do you have my work in it?
Right.
Like if it's a music one, is my work there?
Well,
are my recordings there? Are my lyrics
there? Isn't
that
what Google does?
You can search the AI engine. I don't know.
Well, you can search Google and your name will pop up a few times, I'm sure.
Yeah, but I'd like to know whether
work.
the AI was trained on my.
I
would like to know if it was trained on my work. I mean, that would be something good to know. Just to start with, was there a license stuff? I want to say something though about a point that Keith was starting to make. The problem with generative AI and there's a concept called fair use. I know many of you don't know what this is, or if you've heard of it, you know that it's some way that you can use somebody else's work or part of somebody's work and stuff like that. But it has a rich history. This notion of fair use there's a rich history of this, and it was sort of designed so that, like, for instance, if you're writing a story, a review of my album, you can quote part of my album, right?
Mm-hmm.
You know, that's fair use. That's a fair use snippet of it, and because you got to talk about it to report for criticism, journalism, news reporting, stuff like that, right? But it's always important when you're doing a fair use study or a fair use ruling for the judges that look at this. They one of the things they look at is, like, is this person who's using this work, are they creating something that's going to compete with the original work? Mm-hmm. Is it going to wipe out the market for the original work? So, like, for instance, you're a graphic artist, somebody comes in, scrapes your work, and then you put up an AI and it'll create a work in that graphic artist style. That is directly competing with that graphic artist. And that should not be fair use, right? So one of the first steps in figuring that out for an artist is to know what the AI was trained on, mm-hmm. to be able to query it to see if it was trained on your work, right? To see if they're, basically making a unauthorized copy or derivative work of your work to compete with you and undermine your revenue. Mm-hmm. Nothing new under the sun.
Well, why are they so unforthcoming about what they're scraping? Because they don't want to pay for it, I guess, is the short answer. Keith, is that your experience?
Yeah, I think that it comes down to money, right? Mm-hmm. I don't know. Are AI companies making money? Actually, I don't know. But I don't think so. But they it comes down to having to pay a license fee to the creators, to the copyright owners, in order to ingest their works to train the AI. And a lot of them think they don't have to or don't want to, because that would obviously cost them a lot of money.
Yeah, and internet search engines got away without paying for news for a long time, and they still do in many cases. Lana, what's your take?
Yeah, my question, I second everything that David said and Keith saying, but do they even know? Are they not transparent because they don't even know? They've just scraped the entire internet and we don't know. Like David said, I would love to know what the AI is trained on. Do they have my material? Are they using my voice? will.i.am had this wonderful viral moment on AI, and he said, I can't use a Nike swoosh, but you can use my face and my voice. And why are those two things different? And with what David was saying with the fair use laws, I think we really need to redefine them for AI specifically. And until we do that, we have $0 to stand on, and we're asking for 0% of zero right now.
Mm-hmm. That's an interesting question. Maybe we need to register our faces, which maybe has already been done for us without our permission. And then we'll have it registered, federally registered, like a trademark, so we can enforce it if we need to.
Let's do it.
Is that ludicrous, Keith? Is that ludicrous?
The new thumbprint.
Yeah, well, if we're going to start doing that, can I use a photo from like 20 years ago? At least I had some more hair.
Well, Bruce Siegal, now you're involved in sports and you work with a number of athletes. So there's, there are the superstar athletes, the celebrity athletes who've always been very protective of their image and likeness. But what about the mid-level, so-called what I call mid-level athlete, who's maybe not a superstar, but is visible? They play in games, they're on TV, people follow who they are. They have followers. Are they becoming more aggressive about enforcing their rights and profiting from it?
Yeah, I think that they are, and certainly, the right of publicity by which they would protect their name, image, and likeness, in that context of, of their image, of their face, that form of protection would be available not only to elite athletes, but, now even to student athletes who for many, many years, because of NCAA restrictions, the restrictions didn't suggest that student athletes didn't have a right of publicity. It was just that if they exercised it and if they commercialized it, they couldn't be a student athlete. They couldn't be an athlete. They would lose their eligibility. But the challenge there in the context of of protecting name, image, and likeness rights, as you may know, those are governed by state law. And so there's no federal right of publicity law. So that means that as one seeks to protect their rights in their name, image, and likeness in their face, a lot of their ability to protect that in under what context may depend upon which state law
Where they live,
is
right.
applicable. I mean, there are about half of the states that recognize a right of publicity. Others recognize a right of privacy and a misappropriation, but it becomes complicated when you've got to figure out, what level of protection do you have based upon, what state law is going to be implicated there.
Which states, I think California and New York have rights of publicity, state rights, correct?
There are about a dozen, yes,
dozen,
including
yeah.
those that specifically have statutes on the books. Others recognize common law right of publicity, and again, others, don't recognize common law right of publicity, but may recognize a right of privacy, from which right of publicity has come from.
So we need a federal law, I would guess.
When you look at the importance of protecting your images, your name, image, and likeness, that coupled with, the emerging rights of college athletes, right? And so now you've also got state by state laws that govern the right of student athletes to, with respect to their name, image, and likeness. There's a strong push going on right now in Congress. Well, there are a number of laws that have been proposed that could create a federal right for student athletes to protect their name, image, and likeness. But this is in the context of, no federal right of publicity law. So it gets a little complicated.
For everyone, should there be a Bill of Rights for AI companies and AI users? Lana?
Yes,
Why?
please.
And what would it look like? What might it look like? I won't hold you to it.
Well, there has to be rules. Like I said before, the art is gray, lives in the gray area, and we need guidelines for it. We have to be compensated fairly. But what would it look like? That's such a great question, because I think that's actually what that's why we're all here, right? Is to figure this out together. I think it would look like maybe slowing down until we figure out how we can not only coexist but thrive with AI. And the only way we are going to do that, and that we can coexist in a way that makes sense for everyone and that is fair, is if we credit, compensate, and get consent from the creators, the people that are delivering the art that is being ingested, or the information, or the knowledge, or whatever it is that you do. So it would look like those three things. Those would be the three keys I would
Great.
want.
And what
David?
it might look like is something that has a degree of uniformity to it, right? As opposed to it being very unclear, what the specific rights that you have. When you think about intellectual property across the board, federal laws govern trademarks, federal laws govern copyrights, federal laws govern patents. So I think that a point is, as important as right of publicity is, and now even more so in the context of athletes and student athletes having protection in the world of AI, where faces can be taken and used in the context of avatars and deep fakes and those sorts of things. Is the time? The question is, and not proposing a legislative solution, but the question is, could the time or should the time be right for a uniform federal law that puts right of publicity at that level of other forms of intellectual property?
David, transparency. Should there be a Bill of Rights for AI and for gathering information and also for providing it and using it?
Yeah, sure. I mean, the first element of the Bill of Rights is you must have consent for what you scrape, right? Whether it's, name, image, likeness, or music, or graphic design, you must have consent. And then, I mean, we start from there. If you didn't get consent and you already scrape stuff, you need to just go out of business. I mean, I'm going to be a hawk on this, right? I mean, I maybe not like burn it down and salt the earth anymore. Maybe I'm just burn it down. I'm a little more dovish on this stuff, maybe as compared to what I used to be when I was younger. But I really don't. I mean, I really think that these companies knew that they were doing something that wasn't going to fly, that was going to violate various laws, various rights of individuals. And then there was like, okay, well, let's just get it so it's big enough and it's out there, and then we'll ask for permission after we've already violated everybody's rights. We've seen what's happened. This has been the modus operandi of Silicon Valley forever. I think there's got to be a punishment this time. It's like, okay, you didn't ask permission, so you don't get to be in business. Now, new companies that come in and ask for consent, we'll let them stay in business, right?
Mm-hmm.
There's got to be, before we get to a Bill of Rights, we got to just establish that, there are laws in this country and we follow them. We don't let outlaw businesses start and then become $90 billion corporations, right?
Yes.
We should be able to profit off of that.
Well, it's also interesting who are the two largest players, or among the two largest. They're among the two largest tech companies. Maybe an accident, maybe not. Keith, Bill of Rights, what would it look like?
So look, I'm all for a Bill of Rights. I think it's a great place. If you look at different organizations have issued statement of principles and things like that in terms of AI, and so Bill of Rights is great, but it shouldn't be a replacement for the law, right? I mean, the laws have got to be in place to, like I said, make sure AI is done in a way that is responsible, respectful, and ethical. And that means, abiding by existing laws, and where existing laws are not adequate, making sure we do have adequate laws that are in place. When you mentioned the Bill of Rights, I thought immediately of, the Biden administration, the White House, and there's been several announcements over the last couple of months about AI companies going in and, signing a pledge with the, to the president and stuff like that. And when I think I read the article initially, I went to my staff and asked them to remind me what's more powerful, a pledge or a pinky swear? I can't remember. We need laws ultimately in place here to make sure that America's most valuable assets, our creators, are protected. And right now they're not, unfortunately.
You're in Washington and you're in the middle of a lot of these discussions. Are we moving towards, as a nation, towards some kind of regulation or guidelines with regard to AI at this point?
So it's interesting. I mean, Congress is known for not moving that quickly. But I think they've all recognized, a lot of members of Congress recognize that they need to move quickly here. And they need to address certain issues. Transparency is one of them. I would be very shocked if there is not some legislation dealing with transparency and labeling come out, especially as we get closer and closer to November 2024 election. You're going to have members of Congress who are just as concerned as creators and people in the creative space and people in the sports arena. And so you're gonna see something pop, and I don't know what it will be or how it will be addressed, but I think you'll certainly see some quick movement. I don't think it's going to happen this year, but I think they're kind of trying to tee things up so they can get off and running next year. I mean, heck, we got to make sure the government stays open first and foremost, I guess, come October 1st. So we'll I guess we'll just have to see.
You know, there, in addition to the other problems or issues that we've discussed, you know, the potential for bias in AI responses is significant. It's been written about. There's some racial biases, certainly, in AI responses. But in addition, I mean, if you introduce sponsorship, not unlike web search, you know, there's potential for influence. You know, it's not just an objective search. It may appear to be, but we have to assure that as well. You know, what kind of political or financial biases come into a response or output from AI. Any thoughts on that? Anyone?
Before you answer, Bruce, I just want to, after
Sure.
this question, to bring it to open up the Q&A
Oh,
to the audience.
Sure.
Yeah, and
Okay,
we have some wonderful comments already, but feel free to go ahead and answer that question.
Can I answer one that I see right now about robot.txt? Is that okay? Is that fair game?
sure.
So this person asked about, you know, whether robot.txt, you can use that, because you can use that to prevent the scraping of your website. And that's all great. That's fine, but it's the way robot.txt works is it prevents anyone from scraping your website. So there may be people who want to be found, for instance, through search engines. And by using robot.txt, it tells the search engine, don't scrape this, don't copy this, right? And so there may be people and companies that want to be found using search engines, you know, and so they don't want to use robot.txt, but they don't want to be scraped for AI purposes. And there is no tool that does that. I will also mention, as I think David Lowery may have mentioned in answer, robot.txt is not respected all that much either. And so that certainly is an issue. So I know that there may be some other technologies being thought about as well that might, but you're just not here yet, I think, that might be able to help out.
Peggy, any other questions or?
Oh, we've had a lot of comments that are thought-provoking. You can make a question out of that, or if somebody wants to come off mute and ask a question one at a time, or put it in the chat. You know, Bruce, you can monitor that.
Sure.
Sure, I'll come off mute. It's Lita Rosario Richardson.
Hi, Lita.
Hi, great discussion, everyone. Really good panel. You know, I'm thinking in terms of federal regulation in the context of transparency, that the federal government should probably consider something that would require disclosure by these platforms of everything that they've scraped, and a penalty if they fail to do that or don't do it properly. And I know there's some issues, but I think the consent issue that Lana raised is important too. And if they require to get consent, that's where you have the opportunity to negotiate for compensation. But I also wanted to just throw out the concept of, you know, some type of statutory licensing. And I'm not saying I'm for this, I'm just thinking, right? That would be required. And I know people like arm's length negotiations, but it seems a little cumbersome in this situation. So I'm throwing those things out as I'm thinking about this. And the robot TX thing, it seems like another tool like that that's just a little better developed might be important, or a tool that you could put on your website to let you know if you've been scraped and who scraped you. So anyway, those are my thoughts.
Can I answer the compulsory license just as the person who's most of my income is subject to a compulsory license? Usually a compulsory license has a compulsory royalty rate, like for songwriters and such. And I mean, you have to be living in a cave if you haven't seen the rates that songwriters have posted per stream for the compulsory mechanical license from streaming services. The problem with a compulsory license is that it is eventually captured by the big players in the industry, and the pay for workers, creators eventually goes down, is my experience. So I would be very hesitant about that. However, there have been a couple models that have been proposed over the years. I think the former the Register of Copyright, one of the Register of Copyrights a number of years ago proposed something called sort of a not quite compulsory system called extended collective licensing. If we were going to do anything, I would suggest something like that, where it allows a kind of opt out, but it does sort of provide some of the efficiencies. It's too complex to explain here, but something like that might be acceptable, but not like a compulsory license like the songwriters deal with the mechanical license.
David, right. for you, you've written about this, but for your hit song "Low," which had a million streams or more, I believe, on one of the streaming services, what did you receive in compensation?
Well, that was on non-interactive digital, so that was actually a PRO license.
Okay.
I think it was about my 40% share was about $17.
For how many streams? How many streams?
For over 1 million streams, it was about $17 for my 40% share of a song. That's non-interactive. That's not technically a compulsory license, but that's a PRO license that the rate is fixed under a consent decree. So it's a lot like a compulsory license, but anything that looks like that drives the rate. Eventually, those systems get captured by the big players with a lot of money and a lot of lawyers, and songwriters generally don't have a lot of money and a lot of lawyers, and our rates get pushed down under those systems. So be careful what you wish for with a compulsory system.
But to answer your question about 1 million streams on, I would say on average on most platforms, that's going to generate about maybe $1,000 or so. Not much.
Yeah. So
it's not
non-interactive is special. Non-interactive is a special case because it's really low, and that was just the public performance royalty. Right. So that's
yeah. So it's still very low. I mean, you have to have tens of millions or hundreds of millions of streams to really make money from streaming at this point. And the model of the compulsory mechanical license in the music business, I guess, is one concept of a model. I know there's also the model for television for the cable TV uses. I'm not as familiar with that model and how they come up with the pricing, but I think the pricing part of it could possibly be resolved. But once again, I'm not really advocating for that. I'm just throwing it out there as one possible solution. I agree with you that there are some downsides of it for the creator. But yeah, so I'll stop talking now.
Yeah, I'll just say that, from the Copyright Alliance standpoint or our members' standpoint, something like compulsory license or even collective licensing, legislating collective licensing or compulsory licensing, we think is at least certainly unnecessary at this point. We see a free market and a freedom to license as very, very important. And we are seeing more and more companies starting to negotiate deals with AI companies and license works. It needs to be done more frequently than it is, but I think that's proof that it can be done. It just needs to be done more. And to do that, you need two to tango. And I know that the copyright community is more than willing. I think we need to have more AI companies willing as well.
Keith, do we have an idea of what those deals look like, or are they, or is that very
Yeah, you're
proprietary.
I think you're asking the wrong person only because we specifically try not to know, right? I mean, we don't
Okay.
want to run afoul of antitrust laws. We just know that deals are made without knowing the details of those deals. We don't really want
Sure.
to get involved in those. So I'm sure to some extent, if you were to do an internet search, you'd be able to find some details about them. But we don't drill down too deep with our members in terms of what their deals
Sure.
are.
Mhm. Peggy, any other questions or?
I
'Cause
don't see any other
Okay,
questions.
I have a question
Yes,
for
go ahead.
for the panel. So to kind of a wrap-up question is, what are 2 points that you would like listeners today to come away with? Bruce Siegal, what would be the 2 most important points?
Well, yeah, I just think that it's a very dynamic and fascinating time that is, filled both with opportunity as well as challenges. And sometimes, when I think about this, and there's so many issues that come into play when you're dealing with AI. But there's a general sense that, hey, there's some really great opportunities and things that we can do with this technology. By the same time, it sort of reminds me of the beginning of the .com time, when there was sort of fear and trepidation about, where are we going with this? What is, this is a paradigm shift that scares me a little bit. And so sometimes, my sense is that people are, kind of looking at this with, I think, a healthy degree of skepticism. One thing that we didn't touch on that I think is of a big concern is right to privacy issues. And we talked about faces, but what about facial recognition? There's a book that's just come out by Kashmir Hill who talks about that very issue in terms of, we're in a world now where one's face can be detected in so many different contexts. There are people that are prevented from attending a sporting event, maybe because their face has been recognized as being a counsel on the other side of the team.
That actually happened at Madison Square Garden.
It absolutely did. And just, the thought that, you can walk around all over the place and there are things that are recognizing you, for things that could, be like that to preclude you. But also, one of the general counsels that I asked about their thoughts of, the world of AI, his thought was he's a little bit concerned, from a fan perspective. And so facial recognition that would allow, when you walk into a store, for example, and all of a sudden, all this information is known about you, and you start getting texts about what you should go be purchasing. It's just, it is a world that is wrought, I think, with privacy issues, which should certainly be considered and thought about in a thoughtful way as we move into this area.
Great, thank you. Lana, 2 points that people should recall from this conversation, if nothing else.
Sure. So, in closing, I was thinking deeply about this, and I myself am a database of every song I have ever ingested, heard, every movie I've ever watched, everything I've ever experienced. So, when I get on mic, I bring every single life experience and influence onto that mic. The difference is that I paid for those experiences, be it a YouTube blanket license, like David was talking about, or compulsory, whatever it is, license. So we paid for those things. And what makes it unique is the hodgepodge of influences that I've had. I'm not downloading it from a cloud. It's coming out of me from what I've experienced. So I think that's what makes art unique, and we need to keep that intact. And then point number 2, the presence of AI is going to require us all to become more conscious and responsible creators. That goes for both sides, AI and artists. And we have to be excellent to each other. We cannot rip each other off. AI is not the enemy. The fear and uncertainty of it is. And all we can do is just follow that North Star as artists and be as honest in our art and continue to do that. So I'll leave it
David, 2 points.
I keep losing my unmute button. Hey, I mean, I'm going to reiterate what's wrong with asking permission. The other thing I want you to remember is, what is AI really providing us when you've got generative AI? I mean, if you're looking for a movie poster or something like that, there are thousands of graphic artists out there already that would love to do a movie poster for you for a couple $100 probably, right? So, I think we're forgetting is like, generative AI, what is it really giving us? What is the value seems to be that a bunch of sketchy companies that just want to be able to have a bunch of sort of sketchy sort of artwork or something out there that they don't pay for, right? Somebody somewhere needs to make a better value proposition for generative AI, because I'm just not getting it. The only value proposition I'm getting is, well, we're not paying the workers, right? That's the only thing I'm hearing, right? I'd love to hear some better proposition for generative AI, because I don't hear it.
Do you think there'll be other generative AI companies down the road? I mean, the ChatGPT, which Microsoft's heavily invested in, and Elon Musk started as a nonprofit, as many of us know. That's pretty big and pretty powerful and pretty present right now. Bard, Google's is getting good momentum. It seems like there are no or very few smaller players in this space. I don't know what your experience is, David, and others.
Well, when you weaken intellectual property rights, that just means whoever has the biggest computer wins and becomes the monopoly, duopoly, or triopoly. We have seen it over and over again. If you want to stop monopolies, the original sort of sin of the digital age is like, oh, if we weaken copyright restrictions, we'll get all of these different players. We'll get thousands of small players. We did not. You're flying it. You end up with triopolies, monopolies, duopolies at best, right? Doesn't happen.
Keith, we'll end with you. A couple of points that we should leave with, you'd like to leave with listeners today?
I'll be brief since I know we're coming to the end, and I'll mention something I think that hasn't been mentioned yet, which is words are important, right? Which is, and how we talk about these things, it's very important. And I see a very, very troubling trend here. The trend is to dehumanize humans and to humanize AI. We've heard it a little bit even here today, right? We heard David refer to hallucinations, right? We hear others talk about AI observing, or it's like very humanistic traits. That doesn't happen. That's not how AI works, but it's part of a master plan, right? To make AI seem human and see like, look, humans do this, AI should be able to do it. And the opposite is also true, right? We kind of are dehumanizing humans. We're dehumanizing what creators add to the mix here, right? We've heard people refer to copyrighted works today as content and as information and as data. It's not information, it's not the data, it's creativities, right? It's creative works. It's so we need to be careful how we talk about these things as much as is kind of the results we're searching for here. And I think that's very, very important. It's very troubling to me to hear. I'm not talking about the folks here that are speaking, but to hear more the greater conversation that's happening out there. And this seems to be a trend, the belittling or devaluing of humans and the increase or humanizing of AI. That is extremely troubling.
Yes, indeed it is. Peggy, do we out of time? I think we just hit the spot.
I say bravo to
Okay.
Bruce Berman. Thank you, Bruce. What a great job moderating. And thank you, panelists, Bruce Siegal, David Lowery, Lana Love, Keith Cooper-Schmidt. I am just in awe of this wonderful discussion. It is exciting, with AI and terrifying at the same time. And I heard .com, and if I recall, the .com exploded. You know, it kind of died and then got built back up. So I think we're in for it's like a wild west. Thank you all for expressing yourselves so in an authentic way. I want to also, as we close, basically to say Bruce Berman has a podcast called Understanding IP Matters. So find him on Apple, Spotify, Google, and I think that he will delve in even deeper into things that we didn't get to today. And please stay with us. We're USIPA, which is USIP Alliance, Entertainment, Arts, and Sports. We have social media out there, and we will be keeping you connected. Thank you so much for joining us, and we're going to say good night. Thank you all.
Thank you. Good night.
Thanks, everybody.
Thanks, everyone.